So, I am an attorney, and one of the things I specialize in is estate planning. And one of the biggest questions I always get is, what is the difference between a will and a trust? Glad you asked. So, when we think of estate planning, most people think of a will. It's the document someone signs before they dies. It's the document where someone is able to outline their wishes as to how their assets are transferred upon their death. So this is known as a testamentary will, and we have the testator, the person creating drafting the will. Then there's what is called a trust, and there's many different types of trust. So a trust does the same thing that a will does, meaning you're able to outline who gets what in terms of your possessions upon your passing. So with that being said, they have something in common, but what is the difference? So one of the major differences between a will and a trust is a will has to be admitted to probate. Meaning, when the person creates the will and it's signed, it has to be filed within the county of where that person passed. Meaning, if someone dies, you have to get their will and it has to be filed in the appropriate court. And that is a public document. If anyone dies, you should be able to go to your local courthouse and retrieve a copy of the will. That means all of the wishes that person wrote down are available to not only to the family, but to the general public. And that goes contrary to what a lot of people assume. One of the common things or tropes in a movie is that when someone dies, there's an attorney who walks in with a briefcase and sits down and does a formal reading of the will. That's not the case. If you're in the possession of a will, you have to file it immediately or as soon as possible or as soon as you can locate it so it can be discoverable and part of the public record. So that is a will. A trust is completely different. The only people who have access to the trust are the people that you share it with and the person that you appoint with giving the instructions. So that typically is a trustee or the successor trustee. So you're writing down all the wishes as to who gets what and how your affairs should be handled, but it's a private document. It does not have to be filed with the court. No one is privy to that information except the trustee and, of course, the people who are receiving from it. So that's one of the major differences is the privacy component in it having to be filed with the court. Another benefit, I'm going to call it a benefit because it is, with the trust is that it works with you or it grows with you. You're able to receive benefit during your lifetime. So during your lifetime, you're able to put your home and other things that you own into a trust. So your trust is able to own it, manage it, and protect it. You get legal benefits from it being in the trust. You're protected from lawsuits, debts, and well, not just debts, but it protects you from possible suits. It limits your liability. So there's benefits of having your assets in a trust now. Another benefit or a pro of a trust is you're also able to dictate and put down guardianship for your children. So if you have minors or other people who are your dependents, your trust can speak to how, who's the guardian and how those assets can be used. So this is a very important thing for family members and parents when they're talking about creating a generational legacy or a generational trust. The trust itself can spell out not only who gets assets, but how it could be used. So for instance, life insurance. We might have heard stories of someone receiving a large life insurance policy, and it may not be best to receive that large windfall of money. It is more practical in some cases to put it in a trust so you could outline different milestones as to when the beneficiary could receive the life insurance. Some people may say that if, they have a minor child or minor dependent, that child can only receive money once they receive a certain age or when they graduate high school or college or when they want to get married or purchase a house. You're able to be very particular as to when they receive the funds instead of a large windfall of money. Another pro of a trust is I discussed real estate. I highly recommend anyone who owns real estate to put your home in a trust because you want to avoid probate. You don't want to have to hire an attorney and go through a judge to allow for the transfer of ownership. If your home is in a trust, your beneficiary is able to immediately able to receive the property upon your transition and passing. A trust, depending on the type of trust you get, is a one-time fee. So if you get a living trust, you are able to pay that attorney up front to help you draft it. And then you're supposed to review your estate plan every 5 to 7 years or after any major life event. So what I like to tell my clients is when they're creating a trust is that we want to think in a 5 to 7 year block because you're going to continue to grow. Your family may grow. You may acquire more assets. So you can always amend it and update it, and you can meet with your attorney and they can help you revise to have it meet your current needs and where your family is. So no, there's no annual fee, but of course you would have to pay money to have it amended and updated. So I highly recommend that everyone has an estate plan. More people are familiar with a will and the concept of a will, but anyone, in my opinion, who owns real estate, it's recommended that you have a trust. It protects the assets from possible liabilities like medical bills, debts, making sure that the home is protected. There's privacy. It avoids probate. So for that reason alone, I recommend a trust over a will. And a trust isn't just about a house. It can be, about jewelry, cars, businesses, your personal artwork, family heirlooms. All of that can be included as well. So for that reason, a trust is like a will times 200 because it does everything a will does and more. So again, as an estate planning attorney, you always need some type of estate plan. And I do recommend that you feel free to meet with an estate planning attorney, talk about the different options, do your research. And if you realize I said an attorney, because I do know the temptation may be out there to do it on your own, go online, talk to a friend, use AI, but the danger is doing it wrong. If you do it wrong, everything you thought you did, you end up paying twice on the back end. So you trying to save money up front will cause you substantially more in the end. So I recommend talking to an estate planning attorney so you can make sure it's done right. You want to make sure that during a difficult process of death and possible grieving, that there's a clear plan in place and no one has to question how the document was prepared. Avoid court, avoid attorney's fees, avoid lawsuits. So talk to an attorney. So this is again has been the difference between a will versus a trust. Follow me for more information. Thank you so much. Bye-bye.